it's all right for you to give me the indictment or, you know, other stuff like that. Because if she would have happened to go first, I'm sure she would have asked about movement and about Rule 615, and you would have been left with nothing.
Right. Typically, the prosecution does go first, and we don't have 2 copies of everything, and so that's why I said, "Are you going to introduce this?" And she said, "Yeah." And so I gave her all the documents.
Okay.
So
Well, I know typically the prosecution goes first. That's why I called on you. Because sometimes a lot of judges will call on whoever stands up first. And so if you can stand up before the other team, a lot of times you'll get to go and you can, even as the defense, give in all those documents and, you know, shut them down.
I was really supposed to tell them about the documents and then just taking them from Kim and giving them to you.
I want to give them to you. Excuse me?
All right. But yeah, there needs to be some more confidence issues. We can work on that. As far as openings go, Kim, there are some things we need to straighten out with the story part. Coach Mays, if you could email me her opening.
You don't have it. I can email you.
No, the video.
Oh,
today.
just kidding.
Yeah.
And we'll get together this week because there's some definite issues we need to work on. 5 years ago, AMTA had a rule against laptops on the table. I don't know if that rule's changed. I don't think it has.
Yeah, I didn't notice that still.
No computers on the council table.
Yeah.
It needs to be as neat as possible.
Yeah. Let's see.
In fact, for competition, my recommendation would be, when you get competition, you have one little notebook, and I want to make you some notebooks. with
Yeah,
stories
they're all
and
going to be
everything.
uniform. Those are things we'll address right before competition. But Ali, your story was a lot cleaner and easier to follow. There were a few places, like when you got to a road that should have been lit, a road that should have been at a guardrail, there was some stuff that needs to be straightened out there. If you get with me afterwards, and then at the very, very end, he said that is why that we will ask you to find the defendant not guilty. One time in your opening sheet, the defendant, the very first time, and then after that, you guys should never use the word defendant ever again in the trial. It's always Danny or Miss Dawson or whatever you decide to call her. And Kim, at the very end of yours, you sort of repeated your theme that you used at the very opening. I mean, like, you sort of repeated that first sentence, but it wasn't quite the same.
Yeah.
I mean, like,
You want it to be like the exact same?
Yeah, oh, absolutely. So that it sticks in the head.
Okay.
All right, and that's all I got, you know, other than straightening out some of the story issues. They were both very good.
I just got one quick thing, Coach Dees. Kim, you got to watch your facial expressions towards the defendant. You were giving her,
Stalling.
you go to hell look. I mean, be authoritative about her actions, but not her. And and coaches, y'all, if I'm out of bounds, I'll let me know. But it several times you did. You looked at her and you were just, going. So you got to kind of avoid that a little bit. And Coach Mays knows more about that than I do. But it came across a little awkward to me.
Okay.
And also, what's your name? I'm sorry.
Suja.
Suja. You have to be a little more dressed a little more appropriately for court.
She's actually not on my team.
She's on
You
our
just showed
team.
Both females.
Well,
She's just
both
sitting
male,
in.
so I just
we
need
appreciate you
somebody.
sitting in on the last comment. I'll take my foot out of my mouth.
All right, Coach Mays?
Opening statements, she was, throwing a butt, she's never going to make it home in time, but because of Danny Dawson, she never made it home at all. And, you want to emphasize the last part of that.
I thought we specifically.
I'm sorry?
And I'll talk about it later.
Okay. Careful not to switch up present and past tense. We're going to go that way. I'm not sure if you did, but I really like when you do the story and you do it in present tense, but the concern with that is sometimes you might lapse into past tense and say, he did do that or she did do this. That's something just be careful about. I thought you did it relatively well. I just want to give a kind of a warning in that effect. Story needs to be a little bit clear. Take them through the night. Take them step by step. You've listed a lot of the facts, but you've got to take them through a story, paint a picture for them. Be careful with things like mentioning a fatal crash analysis and not explaining what that means. I think people are more familiar with accident reconstruction, though you don't want to call it an accident. So reconstruct what happened that night or something like that.
Crash
reconstruction. You're up, Kim, you have the tendency to follow a certain kind of predictable pattern. And that's probably one thing that we want to look at the video on, but the rhythm, there's got to be a rhyme to the rhythm. Defense opening, be careful with the baseless assumptions thing. He admits that he was tipsy to the officer, so be careful with that. You might want to throw in something effective. He wasn't, they assumed he was legally drunk. They assumed he was over the legal limit or something to that effect, instead of saying they assumed he had drinks or something like that, because you're raising their burden, or you're raising your burden. They would have you believe he's some kind of monster. I think that's probably too much argument. You're going to be able to get away with a little bit of it, but I'd probably take that line out. Now, and also, sometimes it's a lot more effective. The prosecution has got to paint him as a monster. That's what they want the jury to think. And you come up and tell about this person that's struggling her way through college and things like that. I think it would be better if you just left the line out. You went to a lot of detail, read the background. I think I told you to bring in some background information. But you went into a lot of detail. Make sure you, maybe on a cross or something like that, you bring out something about her background so it makes it look like you kind of satisfied that the opening statement. Maybe through Taylor Hobson cross or something like that.
Okay, go into the background.
Just like she's a college student and stuff like that. Okay. You just bring that out.
Just
to the
because you
cross.
said an opening doesn't mean it's in. I mean,
Right.
Opening statements aren't evidence.
Yeah.
So in the trial, at some point, ask somebody about,
And you can get that in through cross or Hobson, I think. You skip the story. I mean, you kind of skip, and correct me if I missed this. You kind of skip the story part of the opening statement. There was an impact statement, and then there was a personalization of the defendant. There were a couple things in there that didn't really amount to story. You went to the witness roadmap, you did the law, and it concluded. And
Does it expand the story a little bit?
Yeah, expand the story. I would.
Yeah.
Make it a more prominent part. And then mention burden of proof. Did I miss the burden of proof? It's their burden to prove all this stuff.
I said as the defense's case, we had no burden.
Okay, I must have missed it. But make sure in your assumptions you draw that connection. It's not our burden to show anything. It's their burden to do everything. But you said it. And that's all I had for the opening statements.
attorneys in general pretend like, even when the other side's giving their opening statement, especially when your side is, that you're really focused on what they're saying. Like maybe you might learn something that you can use against them in the case. But no matter what they say, don't like react to it as far as either good or bad. That'd be really my last general comment. Are we ready to proceed? Does prosecution in today's case have any witnesses?
Your Honor, the prosecution calls Taylor Hobson to the stand.
All right, Mr. or Ms. Hobbs.
Permission to proceed. Can you please introduce yourself to the court?
Taylor Hobson.
Do you know Vanessa Sullivan?
Yes. We were next door neighbors since we were 8. We went to high school together. She was my best friend.
Do you know Denny Dawson?
Yes, I do.
How do you know Denny Dawson?
Vanessa introduced me to her as one of her classmates our sophomore year in college.
Can you please explain to us what your plans were on the day of September 24, 2010?
Vanessa picked me up around 6:45, and we headed to Chuggy's, a local sports bar, to meet Danny and to celebrate Vanessa's 21st birthday. I asked Vanessa if Danny would be the designated driver, and she said that Danny was more than willing to be the driver. I even asked Danny once we got to Chuggy's.
How did Danny Dawson reply to that?
She said, lighten up, Taylor. Anybody can have a drink or two and still be fine.
Objection, Your Honor, you're said.
Under 802, admission of party opponent.
Okay. So is it hearsay if it's an admission by a party opponent?
No.
Okay. So it's not hearsay and it's an admission by a party opponent. Whose statement is this?
This is Danny Dawson,
The defendant.
the defendant.
Okay. Response? The objection. Yeah, I know it's a losing argument, but if you have absolutely nothing, Your Honor, I stand behind my objection.
Okay.
Overruled. You may ask the question again.
How did the defendant respond to that?
She said, lighten up, Taylor. Anybody can have a drink or two and still be fine to drive.
So what happened as the three of you went to celebrate Vanessa Sullivan's birthday at Chuggy's?
Well, we got a special table for Vanessa's birthday. I had a few drinks and then ordered sweet tea with my meal. Danny ordered straight whiskey and tried to get us shots for Vanessa, and I refused.
Did the defendant stop drinking as it came closer to leaving the bar that night?
Well, I know Danny kept ordering screwdrivers and they kept being brought to the table. I didn't drink any of them, but the glasses ended up empty in front of Danny.
Do you know how many drinks the defendant had to drink herself?
Well, I'm not sure about the exact amount, but she kept telling Pat, the server, to keep them coming strong.
What happened as it came closer to the time of leaving the bar that night?
Well, Danny was looking pretty drunk, and Vanessa looked worried about getting home on time. We had a 20-minute drive ahead of us, and we had to make curfew. Danny said she'd made the drive in 8 minutes before and told us challenge accepted. I asked her not to, but she just seemed to encourage her more.
Was the defendant walking properly?
Not at all. She was stumbling.
Did anyone suggest that she take a cab home?
Yes, we even passed a cab driver in the parking lot on the way to the car. And Danny said, Sam Lyons, the cab driver, offered to even pick Danny up in the morning and take her back to her car. And Danny refused. She said that she just shoved Sam away and said, no thanks, I can handle it. Drive home instead of having you charge me 2 cab fares.
What was the weather like that night?
It was dark, it was raining hard. All in all, it was unsafe weather and unsafe roads.
How was the defendant driving?
She was going 80 miles an hour in a 45-mile zone.
Objection, Your Honor. Improper character evidence. Improper opinion.
Response. Well, improper opinion as to what part of her statement?
As to the speed of the car.
Doesn't matter what it states in an affidavit. Did this witness not just testify that the defendant was driving 80 miles an hour?
Yes.
Does the witness have any way to know that?
She was in the car.
Okay, well, if she can testify that she saw the speedometer or some other way that she knows how fast the car was going, then that's fine. And if that foundation is laid, we'll let that stand in. But if she can't somehow establish how fast she was going, she can't make an opinion statement like that. So the objection is sustained. And that's where you ask for a motion to strike.
We ask that this be struck from the record.
Yeah, the portion about the speed will be stricken from the record. If you can lay a foundation for her to get that testimony in, then go ahead. But if not, then you need to move on. Go ahead.
Permission to
Go ahead.
How fast did it seem that the defendant was driving?
It seemed like she was going 80 miles an hour in a 45-mile zone.
Did Vanessa Sullivan seem to look worried?
Yes, Vanessa seemed to look worried. I know I was scared. I kept asking Danny, please slow down. please drive straight, please quit swerving. And that just seemed to encourage her more.
What happened as Vanessa Sullivan was talking on the phone with her father?
Well, Vanessa called her dad, hope, trying to make Danny see, it's okay, we can be late. And just the music was blaring while she was on the phone with her dad, and Danny kept swerving. Eventually, we spun out of control and we hydroplaned.
Do you remember how you got out of the car?
I don't remember how I got out of the car. I just remember seeing a lot of blood everywhere. Everything seemed red. Somebody told me not to move. And that was...
Miss Hobson, I know this is very difficult for you, but please tell us if you remember anything else